from the appeal court on Nnamdi Kanu. Let's quickly take the up sound. When we come back, we'll now discuss.
The court has delivered its ruling in its wisdom. It's the same court that gave judgment on the 13th of this month, ordering a release or a discharge of Mazi Nnamdi Kanu. Well, the same court in its wisdom has this afternoon, though a different panel, but the same court of appeal, held that there should be a stay to that same order of discharge, meaning that Nnamdi Kanu will remain in custody. That is, for us as lawyers, we don't have anything to do, I'll say, until, especially knowing that the substantive appeal itself is before the Supreme Court. We go to the Supreme Court and ventilate the case of our client, Mazi Nnamdi Kanu. So that is the hope we look forward to, especially against the backdrop that they also made a consequential order that the record of appeal should be transmitted to the Supreme Court within 7 days. That gives a hope and indication that the appeal will be heard within a record time.
Yeah, thank you for staying tuned. Gentlemen, you've heard that on Friday, the Court of Appeal upheld the request of the federal government to stay execution on the judgment that it delivered. For the first time, maybe let me start with Barrister James. I can see the same courts of coordinate jurisdiction making a ruling and also coming back again to reverse the ruling or to take another decision on that same ruling. What's your take on this?
Jude, you know, we as lawyers, most times we do not want to start meddling with judgments or rulings of the courts. But if you ask me, I am miffed, I'm baffled at that decision. Why am I baffled? First and foremost, it is seeming as though that the Court of Appeal is sitting on appeal on its own judgment. A Court of Appeal, competent Court of Appeal, has given a judgment that set the man free, discharge him. How can another panel sit and give a divergent ruling when the federal government is in contempt of that court order? I don't know what is happening. In fact, I read something some time ago where the chairman of BOSAN, Chief Olani Pekun, complained about the different rulings of the Court of Appeal. Contradictory ruling, confusing everybody. There was a ruling before this Court of Appeal ruling.
Yes, October 13, yes.
That says that during the military regime, during the military regime where the Court of Appeal refused to grant a stay of execution. By the federal government because they were in contempt of court. You must come with clean hands. A court of competent jurisdiction has given a ruling. Free this man. You disobeyed and went to court, that same court, and that same court granted it. The court shouldn't even be hearing them because they're in contempt already. What are they telling us in this country? In fact, I'm troubled myself. I'm troubled.
Okay, Barrister Kolawole, talking about contempt of the courts, I know that when the courts made its judgment on the 13th of October that Nnamdi Kanu should be free of all terrorism charge and other this thing, absolving him of any of those things because of the manner in which he was brought back to the country. But if you look at over time, I remember there was a time when we had some conflicting judgments, high courts, over political matters, where Rivers had a ruling, Cross River had a ruling, Jigawa had a ruling, I think Imo too had a ruling. And eventually those judges were sanctioned. What happens to this panel in the same Court of Appeal?
Well, that's a very, very difficult question. But we'll try and try and navigate it. Just like my colleague had said, the different branches, or is it panel or jurisdiction of the Court of Appeal are the same. They have a court of coordinate jurisdiction. And if one of the panels had made a ruling, which was even, it was a kind of final decision, so to say, that the man has no case to answer. One would think that the Court of Appeal has become functional officials with regards to anything that has to do with that kind of, with that decision. The fact that the Attorney General himself went to that court to file that application in itself raises a very troubling ethical issues, in the sense that the Attorney General ought to know that that court has become functional officials with regards to that decision. If he has any complaint to make with regards to that decision, he ought to have gone to the Supreme Court. Immediately, they have also lodged, I think, an appeal at the Supreme Court. And in fact, look at the pronouncement of the Supreme Court, that the Attorney General seems to have a grip of his case, that they appear to be confused with regard to some of the papers that filed in there. Well, as to what sanctions to give to whoever may be making contradictory judgments or whatever, or who is kind of undermining the process of statistics that is well established in our judicial system, will lie on whoever makes a complaint. Except there is a complaint, except there is a petition to say, look, this has been done and we think it is wrong, and then it is taken maybe probably to the NJC and what have you. It might be too early to now begin to speculate what is going to happen to those judges who gave this conflicting decision. But we must also remember, because I haven't read the details of the paper that was filed at the court, before this second panel. Whether there are new facts, whether there are new issues, whether there are new cases they have made available or put before the court that they intend to arraign Kanu with another. We wouldn't know. But if that is the case, one thing is paramount. Immediately a court of competent judicial say, look, this man is discharged. And no new charges have been filed in the court against him. The onus lies on the security apparatus to let the man go. If you now come up with the new charges, it's for you to now go and make an arrest and then bring back to court. And so long you don't do that, you, like he said, you are falling contempt of the court. And there ought to be sanctions for that. And one of the sanctions will be that once you fall contempt of the court and order, you've gone with a dirty hand. The equity ordinarily should not entertain any.
You were asking the question of you don't know what has been filed before that panel. I know one of the things the judge said was that what the counter affidavits that was filed
by the Kanu
people was misleading. So we don't know whether that same counter affidavit was filed by the initial panel that gave that ruling. We don't know, but this one said it is misleading.
Demand for him to enter into the merits
of the case.
It means he's going back to hearing the matter. The court is functus official. File that at the Supreme Court. In fact, let me tell you, Jude, the moment the Attorney General, before the ruling, started making what I call it, he started making comments in social media and print media. Before the ruling, I started finding some things fishy. the matter was sub judice, but he came on air or came on social media and started telling why they cannot release Kanu.
Yes, I also heard at least the lead counsel.
No, the Attorney General himself.
Yes, I know.
Made some comments that telling the country
why the federal government
will not
release Kanu.
Will not.
Yes, we heard that.
The man before the ruling had already told Nigeria that they were going to disobey the Court of Appeal. Now, what the Court of Appeal has just done is to legitimize the disobedience of the court.
Okay, yes, let me hold you there just to ask this question. If this is set as a precedent,
we are in trouble.
Yes, because it means that the High Court too, when a case is heard, they can go back to High Court to hear the same matter.
Now let us look at it. Let us look at it from two different perspectives. Okay. What if immediately the ruling or the order was granted that Kanu should be discharged, and Kanu refuses to follow the DSS people and says, "Well, I've been free here, and you are here. I'm not going with you. I'm a free man." What would have happened?
Which he could have done.
He could have done that. He could have said, "Well, why am I following you? I've been freed by the court. You brought me to court. Okay. The court you brought me to have freed me. There's no reason why I should follow you back to the DSS cell. Yeah. But he didn't. So what I'm just trying to say is this. Why would the Court of Appeal give legitimacy to disobedience of court order? The man, as at today, is a free man. As at today, because there's no judgment contrary to that judgment. So the judgment of the court is this man has been discharged. Okay. Even a stay of execution cannot remove his freedom. He has been discharged.
Okay,
and there are no fresh charges.
There's no fresh charge.
Let's now come to the morals. The way Kanu was brought back to the country. I read somewhere that actually flouts. Let me see. That flouts it violates human rights according to Article 12.4 of the African Charter of Human and People's Rights, as well as Chapter 4 of the Nigerian Constitution. How would you view that? And that also is coming from federal government, violating the rights of its own citizens.
Let me say this right away, that immediately Kanu's case came up, I'm one of those who have been very vociferous and saying that Kanu's case is a political war. And it's a case that should not be subjected to any judicial pronouncements and all that. And I took my cue from the circumstances of that case. And the decision that the Court of Appeal, the first decision of the Court of Appeal, which kind of discharged Kanu, gave the federal government a kind of a leeway or a breathing space to really resolve that case in a very political manner, especially taking cognizance of what the United Nations have said with regards to that case, that Kanu should be freed, and that whatever they have done to him is in violation of his fundamental human rights. They even said that he should be compensated for what has been done to him. But be that as it may, as much as Kanu has my own sympathy, I also have a little disagreement with the first decision of the Court of Appeal. Why do I say this? I have looked at our jurisdictions and at our laws, the Constitution, the Criminal Code, the Penal Code, and all that. I haven't found anywhere in which the manner in which a suspect is arrested become a shield or a bar to his trial. I haven't seen. And I will give you a few examples, both locally and internationally. The first example is this. Let's, in a very jocular manner.
Don't you see that as a lacuna?
No, it's not.
If his right is being infringed upon.
Where? What he could do is after the trial. If he's now discharged and acquitted, then he can file for damages for the violation of his fundamental right and his extraordinary rendition from Kenya. Then second, we will contest it, we will debate it. I will give you two examples. Local example, they may be fleeting and all that, but have some semblance and all that. I was told, or we heard from the grapevine, that Mr. Evan, who is being tried for numerous kidnap cases and all that. On the day he was going to be arrested in his house in Magodo there, the wife had prepared the kaikon, choice wine was on the table, Izewu and what have you. When Abakiyari and his team stormed the place to arrest him. And immediately they got in there, gave the man some dirty stuff, manhandled him and all that. He tied his hand to his back and then chained his leg, put it, chained him to the dining table and all that. And now the girlfriend to begin serve them the Izewu and all the things that the wife had prepared and all that. And then thereafter, when they were satiated what they were doing and all that, they took him another. Now, Kanapaki, can never now go to call, look, my Lord, I was trying to eat my food and Izewu and all that when these people stormed me and all that, and then took me in there, trying me for this social offense. That is locally. Then go at what happened to Hush Puppy and all that. Hush Puppy was a resident, I think, was it Dubai or where? Dubai. Or where was it based and all that. But the American people had flagged him. There was a red flag to the Interpol and all that, and they were already looking at it. Immediately they knew where he was based and what have you. They liaised with their
network in Dubai.
Network in Dubai and all that.
Yes.
And then they took him back to America where he's been tried and all that. As the American lawyer defending Hush Puppy ever raised that local, because of the circumstances and manner in which Hush Puppy has been brought to the U.S., the American court does not have a right to try him. Under our law, the circumstances in which a suspect is arrested and brought before a court of competent jurisdiction most times become very, very secondary. And that is why you find out in both the Administration of Criminal Justice, the Penal Code and what have you. Sometimes you read in there that security officials can break in and break out in the attempt to apprehend a fleeing suspect or a fugitive offender. And don't forget, Kanu was already flagged. The Interpol was already put an alert with regards to, and there was also another of a competent jurisdiction in Nigeria saying that wherever you can, wherever and at any time you can,
jumped bail.
At this moment, jump bail that you can arrest him.
Yes.
And then so for me,
Barrister,
that's why I say
Barrister James,
the circumstances of arrest ordinarily is never a shield to prosecution in most jurisdictions. It could only be after you have been tried and acquitted, become a subject of seeking damages for the violation of a fundamental human right.
To further help the discussion, according to what Kanu said, he was arrested, he was blindfolded, he was tortured and chained to the ground for 8 days.
No, that's not
in Kenya.
That's not even where I'm going to. Sir.
I'm coming. Yes, I'm throwing the question to you now because he is saying that after the matter, you can now file like a civil
if it's acquitted, yes.
That
if it's
file a civil proceeding that his human right was infringed upon.
Yes, yes.
So what's your take on that?
Okay, first and foremost, the circumstances which my learned brother here had cited, they are not in pari material to the situation
on ground.
First and foremost, where is Kanu in the world now? Presently, where is he?
He's in DSS custody.
No, he's supposed to be in Kenya. Kenya has no record that Kanu has left Kenya. But they have a record that he's in Kenya. That's a breach of international law. So you can't tell me that because Evans, who is in Nigeria, a criminal in Nigeria, and then the officials in Nigeria busted a criminal in Nigeria, then he should be shouting fundamental human rights. No. This man is in Kenya as we are speaking now. His passport is in Kenya. You did not extradite him normally.
There was even a high court ruling.
Even in Kenya.
The recent one in Umuahia. That you should return him back to Kenya.
Return the man back to Kenya. If you wanted that man to be tried in Nigeria, why didn't you go through the international practice of extradition? Like you said, Interpol was already flagged. If Interpol was flagged, they should have held him in Kenya officially and started the process of extradition. But no, why did you have to go through brigandage in another country? And again, who kidnapped him? They weren't Kenyan officials. They were not Kenyan officials, they were thugs. Because even there was a trial in Kenya. There's a trial going on in Kenya as we speak.
On the matter?
On this matter. On this
Okay,
matter.
just like the Sunday goes.
Exactly.
Okay.
And the trial is that how did you people connive to bring Kanu to
Back to
kidnap him?
Nigeria.
And the officials are denying that it's not true. We don't know. The officials don't know. And then based on what he's saying, that there's a court order to arrest him anywhere. It is arresting anywhere where the court has jurisdiction.
Okay.
The court that gave that order does not have jurisdiction internationally. So, how many policemen in Nigeria can go to Kenya and arrest with their police uniform? How many? So when you
That's the duty of the Interpol.
exactly the point. That's what I'm saying. So if they went through legal means, nobody will be shouting. And then you cannot put something on nothing and expect it to stand. The issue is not even fundamental human rights. It is flouting in, that's what they call it, rendition.
Rendition, okay.
And we are not talking about, you cannot come and tell me that you are bringing illegality to legality. The federal government has now been termed as kidnappers. How can kidnappers try another person when they also have committed crime? Okay, let's assume the two of them they are criminals. Who is justified to try who?
Okay, Barrister
Now,
Kolawole. Wait a minute. I'm coming. You say.
Wait a minute.
I'm coming, Barrister Kolawole.
All right.
You see, there is this thing I read somewhere. They said this rendition now has now expanded the matter of Kanu far beyond the realms of Abuja trial.
Exactly.
And open to new legal frontiers. So I don't know. What will you say about this now? So it means that they could do same thing to Sunday Igboho. That's from your take, sir. Maybe we'll just wrap up with that and go to the next topic. Yeah. So
Underline one fundamental word that I used. Shield.
okay, shield.
The manner of arrest, I still insist, has never been a shield to the trial of any fugitive offender anywhere in the world. The reason I gave you some of these little examples as this, all the time that the Israeli security people go out there to go and kidnap people who have offended against the state of Israel. As the Israeli,
let's not speculate here. You know, we hear.
I will still remember. I will still remember some of them.
Whether the issues
I
were
will.
raised.
Okay, I will give you one example of the American. You remember the Panamanian case when an American,
what's that man's name again?
Ortega, or what was that his name? What's that his
Ortega.
name? A president who was said to be dealing in drugs and what have you, and all that. When the American invaded that country and went and picked him up and took him to America to try him, did the American court reject the trial of the father?
No, was he said to be extraordinarily rendited? You need to come and tell me.
That is what I'm saying.
Was he said in that court?
I am not contesting that he is not extraordinarily rendited. Wait a minute, the law. Wait a minute, the law. I am not saying he is not extraordinarily rendited. I accept that his right with regards to that has been violated. But I am saying, under our law,
he's saying that under
our law, it is not a shield.
That is not a
It is not a shield to you being tried.
This is the first time it is
after the trial has been concluded, and then you are acquitted, then you can now say, my Lord, aware. My rights have been violated.
No.
But the point
If
is,
the circumstances in which people are arrested or apprehended and taken to court now become a shield to their trial and all that, there's so many trials that we see in court will not fly.
Now, like I said,
it will not fly.
Like I said before, what the issues in this matter is
don't let us be emotional about these things.
This extraordinary rendition has not been raised in Nigeria. Tell
And
me where it has been raised.
And the issue is this: do you think it is possible for the Nigerian security people to have picked up Kanu in Kenya without the complicity of the security people over there?
Look, stop assuming. The Kenyan government is saying they are not aware.
What would they have told you?
It's in court.
That's what they would tell you.
Even United Nations.
To avoid the liability.
Wait, hold on, my brother. My brother,
To avoid the
you are
liability
not
to hold
assuming
with
for them. The United Nations came up and said the way you brought Kanu was illegal.
If you know of any law,
I cannot
if you know of any law, any statute in Nigeria that says that the circumstances of arrest of a suspect is a shield to the trial of that person,
how many decisions have you heard on extraordinary rendition in Nigeria?
Cite it.
That's this is a new frontier. And I keep telling you, sir, they have raised the issues in the Federal High Court. The Federal High Court said no, that you are talking rubbish. I've discharged eight charges against you. Come and answer to 7. They went on appeal. The 3 wise men there said, look, you cannot bring this case here. That ab initio. Federal High Court had no jurisdiction. This is the first time I am hearing, I don't know whether they have brought it up before, that there has been a case on extraordinary rendition challenging the jurisdiction of the lower court. If you have anyone, tell me.
Okay.
Tell me.
So let's.
For now,
This is the first time we're hearing it,
okay.
and this has become a precedent.
For
and
now.
for again, before you go on,
Yes.
there is a precedent in the court of appeal that says that when somebody has been discharged
Okay.
on a whatever charge, and the court has disobeyed, you cannot come and grant a stay of execution by that same contempt. No.
That's elementary principle
Now,
of law.
we
Take it to the higher court.
That's elementary principle of
what
law.
you are
Yeah.
saying, whether there is a law that says that the circumstance of your arrest shields you, you are saying another thing that has not been challenged. Now it has been challenged.
Okay, since now, maybe after the ruling now, we now have a precedent.
Exactly,
so
that's what I'm saying, sir.
Let's keep it